It's the day before you go on holiday. Everyone's in a great mood. Everyone's packing. Everyone's happy and looking forward to the holiday. And then there's a knock at the door. The postman brings with him a huge stack of documents in a folder bound in brown paper by special delivery. And instinctively, you know that this is important. You get it through to the office and you open it up to find out you've been sued. They are applying for an injunction against you and they are suing you in the High Court for £75,000. Suffice to say, you have to then think about that for the remainder of your holiday because you can't really deal with it whilst you're on holiday unless you take it with you. Which, when that happened to me, I thought about taking it with me and dealing with it on holiday. All the while knowing that I have to respond within 14 days to at least file off an acknowledgement of service, which gives me an additional 14 days to deal with it. And then I have to deal with it. So this is how I responded to that particulars of claim when it landed through my door. Now again, I'll reiterate for the purposes of this video, it is not to insult or ridicule the company. It is not to invite any negative comments against the company or indeed their solicitor. This video is purely in the public interest and legal commentary and education of sorts to help you to understand what this document is, how you're supposed to respond to it and when. And just so that you know, you are not alone in all of this if you receive one of these for the first time. As a barrister, I've seen countless bundles of documents just like this one, and even for the simplest trial, there's at least one or two of these in the stack when it goes for trial. But for the particulars of claim, that should be a really simple, straightforward document. So please do subscribe to the channel below, help my channel grow to 1 million subscribers, and then I will know that in some small way at least, I've helped at least 1 million people to understand law. Thank you very much for that, and let's get into this document. So the particulars of claim is a very straightforward document, but a very important document. Now, the way that we teach this at bar school, I say we because I am a guest lecturer at BPP Law School, where I teach various bits of law for trainee barristers. I focus on court advocacy because that's the bit that I really love. But as part of the course, we are taught to do drafting, which is statements of case predominantly, but a little bit of witness statements we get into. Maybe I'll cover my witness statement in a separate video. So here's the difference between the two. A statement of case should be a very concise and factual document which sets out the facts upon which you rely to bring a cause of action against another party, be that for an equitable remedy such as an injunction, or in the case of monetary loss or financial loss or breach of contract and such things, damages, which just means money. So you set out the facts that you rely upon to bring and prove that claim. That is called the particulars of claim. Now, I am also going to set up other websites to help you do these things. I own the website, or the domain name at least, particularsofclaim.com and .co.uk. I may be setting up some services on there, but for now, register your interest on BlackBeltBarrister.com. Go and sign up there. There's a free way of adding your email address to the mailing list there and such things, and there's exclusive content on there and so on. So I'll link those below. But the particulars of claim is what the claimant, or claimants if there's more than one, setting out the facts that they rely upon to sue you. Now, in response to that, we file a defense. Now, the defense, or the response at least, must be filed within 14 days. And if you don't do that, then the claimant or claimants can seek a judgment in default of a response to the claim. If you file an acknowledgement of service, which should be within the response pack, which should also be served with the particulars of claim, and you just, in other words, you're just acknowledging that you've received the claim, you give your address for service and so on, then you get an additional 14 days. So a total of 28 days within which you must then reply in detail to this particulars of claim. Now, there are just a few rules about how you are supposed to respond to each allegation in the particulars of claim. Not least of which that you must respond to each of the allegations in the particulars of claim. Otherwise, you are deemed to accept it. So a bare denial is not normally good enough. You need to deny it and then put forward a positive version of events. But there are, in short, 3 ways that you respond to each of those allegations. You either admit the allegation, so it could just be a very straightforward thing such as who the claimant is. You can just admit that because there's no need to deny who they are, unless, of course, they're being dishonest about it. You can deny the allegation, in which case you deny it and then put forward what really happened, or you are unable to admit or deny and you require them to prove it. We colloquially refer to that as UTAP, unable to admit or deny, prove it. So you put the claimant to proof, but there is no need most of the time to say that you require the claimant to prove those things. Sometimes if you want to make a point, you will say that you do require them to prove them. But with that in mind, it should be a relatively straightforward, a relatively short document, depending on the complexity of the claim. And then you deal with each of those allegations in turn. Now, as an aside and by way of update, many of you have probably caught up with my ongoing debacle with 3. It's still ongoing. Now, I've used 3 as a bit of a story to partner with Saley on this channel. Now, the update is as follows. They've reported now twice to my credit file that I've missed payments, even though when I log in, the bill shows 0. So this is utterly ridiculous, and it just emphasized to me how easy and seamless it was to use Saley when I traveled abroad, to have mobile data access when I'm traveling around. Even when I was in China, I was still doing videos and I got seamless access to the internet because it gave me an eSIM and I just connected to the internet just like that, because you download the app, you don't need to buy anything straight away, but then it's ready for when you travel. You just buy a plan for your destination and then it activates when you arrive. And if you want a discount, you just use the code BlackBeltBarrister at the checkout. We'll give you 15% off any plan you choose to buy for any country of destination. And then it will just activate when you arrive. That's how it should work. 3 should learn a lesson. This is exactly how it should work. So if you want seamless access to the internet when you're traveling around, download Saley today. It'll be ready for when you go. And don't forget the code BlackBeltBarrister at the checkout for seamless access. I couldn't really say more. It was the best thing that I did to make sure that I stayed connected to the internet without any rubbish charges. So thanks to Saley for sponsoring this video and providing you a fantastic service. So let's take a look at the claim that was filed against me. So what I'm going to do in this video is to set on the left the claim and on the right my defense. And the defense was settled by my learned friend Alan Robert Shaw of Art of Law. Do pop over and subscribe to his YouTube channel as well. His videos are fantastic. I'm very pleased that his channel is growing. Do go and support him as well. So let's take a look at what we've got here. Now, bearing in mind what I said about this should be a relatively simple, straightforward, short document. You can see from the right, my defense fits on 7 pages, because even that half of the, or more than half of the first page is what we call the header. Now, I'm reminded to just deal with 1 or 2 of the comments that popped up from the previous video. Some people have asked, why did I blank out the names? Well, because I gain nothing by naming and shaming the company. This is absolutely not the intention of these videos. And so by blanking them out, that is just my way of showing that this is for educational purposes and to help you understand how to deal with a claim, how it makes you feel, and all of what happened, and how I ultimately believe that this claim was a SLAP, a strategic lawsuit against public participation. And so there is no legal obligation for me not to name them. And in any event, the judgment from their failed application for an injunction is public domain. That is available in the National Archives, and it will be forever. So that is now in the public domain. There's a very interesting quirk, rather ironic quirk about that, which I'll tell you just before we dive into this document here. Part of their claim was that I should never mention their company name again. But also part of their claim was that I would pay for any dissemination of any judgment to that effect, which of course would have their name on it. So kind of, I don't think they really thought that one through, but there we go. So let's get into these documents then. So you'll see, as I said, from the right-hand side, my defense is very short and concise, whereas theirs, you can see from the left-hand side, the thumbnails, this was 218 pages long, which is far too long, and there's a couple of reasons for that. So for educational purposes, you understand the reasons, or some of the reasons that I think that was far too long, is that they've stuffed it full of annexes, which are all unnecessary in a particulars of claim. That's not where they belong. There were legal arguments that don't belong in there. There was evidence that wasn't supposed to be in there. And so just on that point, if you recall when I said that these documents are supposed to be a statement of case, a factual statement of case, they are supposed to be, I reiterate, the facts upon which you rely, not evidence, which would be, he saw this and he said that, and this happened and he did that, and this happened, those kind of things are evidence-based. They belong in witness statements or reports or something else further down the line. The facts should be this happened, that happened, this caused that to happen, this caused damages, and so on. That's what a particular claim should really be. And so those are some of the reasons I think this was far too long. But nonetheless, you still have to deal with it. You have to make the best efforts you can to deal with it. You cannot just ignore it. So what I'll do to explain this in the best way possible is I will refer to my defense first and then tell you what bit that responds to, because this video is about the defense rather than the claim itself. So the defense here, we dealt with, let me highlight these so you can see what I'm looking at here. Paragraphs 1 to 3 are admitted. Now, if you recall, I said you either admit, you deny, or you're unable to admit and deny, and you put them to proof. So paragraphs 1 to 3 are admitted. However, that's not all that first paragraph in the defense says. It says, save that the second defendant, me, so I'll just say me from now on, save that I cannot comment on the claimant's marketing puffery, paragraphs 1 to 3 are admitted. So paragraphs 1 to 3 over here are just, this is what the company is, this is what the company does, and this is the company website and whatever. That's irrelevant, really. It's just, as the defense suggests, that's just marketing puffery. Then we move on to paragraphs 4 and 5. Now, paragraphs 4 and 5 do not concern me. Paragraphs 4 and 5, we go over to here, they give a background or an alleged, everything in here is alleged, by the way, because they withdrew this claim in full. If you haven't watched my previous video, they withdrew this claim in full, and ultimately they've had to pay costs. So paragraphs 4 and 5 are their alleged background of harassment regarding the first defendant, the cyclist, but again, not me. So moving on, looking at my paragraph 3 in the defense here, this relates to paragraph 6 of the claim. Now, you'll see here that they've referred to my Black Belt Secrets YouTube channel, although they've said that I'm the creator, owner, and manager of BlackBeltBarrister. So straight away, they've confused the two. So I have to deal with that, and I have to deal with the allegation that I'm the owner, the creator, the manager. So this is a perfect paragraph to tell you how you deal with each paragraph. And this is what we would do if we were teaching trainee barristers. This is what you do. You take the paragraph here, you look for the bits of the paragraph that you can admit, bits that you must deny, and bits that you're unable to admit or deny or comment on or whatever, because they maybe don't relate to you or such things. Now, breaking this down, it might be very important later on which bits you admit or deny. So they've said here that I am the creator, the owner, and the manager of the channel BlackBeltBarrister located at Black Belt Secrets. So that's wrong anyway. So in my defense here, I said that I am the creator of the YouTube channel BlackBeltBarrister. However, as stated on the channel, I am not the owner. The owner is my company, because my company owns the channel. So in any event, by suing me, they've sued the wrong person. And so even if this got to full trial, there's a legal argument as to whether they can claim anything against me at all, because they've got the wrong defendant. Now, as it says here, I am not the owner of the channel in my defense. The channel is owned by the company. The URL for the channel is youtube.com/BlackBeltBarrister, not Black Belt Secrets. So then I have to deal with the Black Belt Secrets bit. So I say the URL for Black Belt Secrets is for a separate channel, Black Belt Secrets. The stated purpose of Black Belt Barrister is as follows. And then so I've clarified what that is, what that channel is for. And save for all that, paragraph 6 is admitted. Because they said here the self-proclaimed purposes to legal services related video, etc. But I've clarified what it's for. My channel states the purpose, which is a channel that provides legal, business, and financial guidance on law, money, legal matters, but not a replacement for formal legal advice. So I'm absolutely clarifying what that channel is for there. So moving on, paragraph 4 of the defense on the right-hand side, save that end users retain ownership of their comments according to Google's terms of service, and the ultimate control of the video's comments and metadata is solely the purview of Google. Paragraph 7 is admitted. So let's look at what paragraph 7 is claiming. And so it'll make sense what I am denying in that paragraph. They say here, the defendants, so me and the cyclist, actively promote the channels using video promotional material, namely the creation and posting of primarily entertaining and informative videos on the subjects of cycling and legal matters, respectively, commonly known as video blogs or vlogs for access by end users. And all material times, they say, the defendant's videos, including but not limited to the text, the comments, the information, the hypertext, the links, the scripts, the material, and the metadata related to the channels, including the titles, belong to the defendants and are within our control. Now, that's not absolutely true. So we have to clarify that in the defense. So paragraph 4, I respond to that by saying, save that the end users retain the ownership of their comments, because if one of you guys, you post a comment, you own that comment and you are liable for that comment. So if you post something defamatory or you post something that is harassment or whatever, you are responsible for that, according to YouTube's or Google's terms of service. However, the ultimate control of the videos, the comments, the metadata, etc., they are all the sole purview of Google because they own the platform. And so, but apart from that, paragraph 7 is admitted. Now, paragraph 5, I deal with bits of paragraph 8. So paragraph 8, it speaks, first of all, about the first defendant, the cyclist. I'll just call him the cyclist from now on. The cyclist posted the first video on his channel, and then I posted the video on my channel. So I say the second paragraph of paragraph 8 is admitted. So this bit here, I'm admitting I did post that video. So because the first paragraph relates to the cyclist and his video, what we would say about a defense here is just be careful what you admit, because if it doesn't relate to you, it's not an allegation against you. So even though it appears to be a statement of fact here, it doesn't relate to me. So always be careful what you are prepared to admit, because some of those things can then later be used against you. So paragraph 9, this was owned and controlled by the cyclist, and these are his details, etc. Again, nothing to do with me. As for paragraph 10, I say, save that are stated above, the channel's owned by my company, not me personally. Paragraph 10 is admitted. And again, in paragraph 10, it's just talking about me. So this is really all about who we are and what's going on. And so again, paragraph 11, the first bit relates to the cyclist. So in my paragraph 8, I say I cannot comment on paragraph 11 as it relates to the cyclist. As for 11.1, this in the claim says pending proper disclosure or further information, etc. They say rather bizarrely the claimants are limited to the remedies they might seek from the defendant's economic benefit from their respective channels is unknown. However, according to information on the internet, you can start earning money on YouTube with 1,000 subscribers and blah, blah, blah. It's all a bit strange. Remember the facts upon which you rely. This is sort of irrelevant, really, to any kind of claim. So in the second bit of paragraph 8 relating to their paragraph 11.1, I say I cannot comment on 11.1 as this appears to relate to hearsay comments on the internet. Hearsay is any statement that is not made in court by the maker of the statement when you are seeking to prove the truth of the comment. So this is something on the internet. So if they are trying to prove the truth of what it says, I mean, why else would it be in the claim? It's hearsay because the author of that text is not going to be in court. So it's hearsay. And hearsay is a notoriously difficult thing for law students to get their head around. So hopefully just rewind that if you want to hear that. But again, no pun intended. So my paragraph 9 on the right here, save that I can't comment on matters in the sole knowledge of the claimants and the first defendant, paragraph 12 is admitted. And paragraph 12.1 is admitted. And then 12.1, I posted a video. So that was that. But then they come on to claims for harassment. And this is where I really took offense. And it is fundamentally wrong in law. So they say in paragraph 13.1 that since at least the 10th of November 23, which was way before I did my video, and presently continuing, the defendants combined to ridicule, scorn, and harass the first claimant and incite end users to ridicule, scorn, harass the first claimant. Consequently, we've combined to pursue a course of conduct which amounts to harassment of the first claimant. Now, aside from the fact that they say that this all started from the 10th of November 23, I hadn't made my video until the 1st of January 2024. But apart from that, my response to that in the defense was as follows. Well, firstly, paragraph 13.1 is denied. And I put forward what really happened. The only connection between the cyclist and me is that I was alerted to the trademark infringement claim against the cyclist. I then produced a video commenting on the law in regard to the trademark infringement claims. That was my first video. I stated my opinion that the claim was unjustified and unsustainable. And then there's a very important distinction here, which we don't very often put things italicized or emboldened in a particular claim, but this was particularly noteworthy. And this relates to the original letter that was sent to me. So I said as follows in the defense, in bold. It should be noted that the claimant's representative later admitted that the trademark infringement claim was invalid, and thus withdrew the claim, because that's expressly what he said in the letter. He wrote, "My clients accept that the original threat of infringement proceedings in his email were misconceived. It misstated the law and should not have been made as such." And then the second bit in bold, which I've just highlighted in orange, was sent in a separate letter and said, "You've received legal advice on the matter, so you must know that any such claim is wild and contumelious." Now, I have to admit that we both had to Google contumelious to see what it meant. And because it was such a strange word, we had to put it in the defense here. And because we aver that this was in relation to the claim, the trademark claim, the Merriam-Webster dictionary definition of contumelious is insolently abusive and humiliating. So in essence, our understanding here is that the solicitor was saying that the trademark claim was wild and insolently abusive and humiliating. In light of this admission, I cannot understand why the claim has now been resurrected. And furthermore, I deny any incitement to harassment. The claimants have not identified any statements within any of my videos that could amount to such. And indeed, in the claimant's third witness statement produced for the injunction application, they said the first claimant admits that the defendants have both made explicit comments stating that people should not harass the claimants, nor their staff or employees. And then we explained that the first claimant states that he was unaware of this until his legal advisors actually watched the videos. I then further clarify and say the simple fact is that one of the second claimants employed was filmed engaging in less than exemplary driving, and people have commented on this. It should be noted that the driver of the vehicle has been convicted and sentenced for careless driving arising out of the filmed incident. I am not and cannot be responsible for the opinions and the comments of third parties as to the driving offence, nor the actions of the claimants in trying to suppress the commentary as to the offending. And now, whilst what I will say is, whilst this is not part of the defence here, but I will say just for clarification, for the sake of the claimant company and its driver and the reputation of the company, etc., I think it's fair to say that according to the solicitor and the documents provided to us, the police wrote about the driver, which I understand was not the director that was named in this case, according to the solicitor. The police prosecuted this driver for the offence of driving a mechanically propelled vehicle on a road or other public place without reasonable consideration to other users. The driver was given a conditional offer of a fixed penalty, and the driver paid the fine, which is why, in my view, this is why cyclists film drivers doing this, because it is a danger to cyclists. But we save the debate between cyclists and road drivers for another video, because a lot of people do hold the view that cyclists are a little bit egotistical in the way that they do that, but that's the debate for another video. The whole point here was that this one driver in this incident was prosecuted, and this then all blew up out of proportion. Now back to the defense. I say at paragraph 14, my overriding view about this case was, for the avoidance of doubt, it is my position that this claim amounts to a slap, a strategic lawsuit against public participation. I say the only connection between the cyclist and me is that I produced a video commenting on his video and the claimant's attempts to suppress the video. I had not incited any harassment, scorn or ridicule against the first claimant. They are invited to point to any words within my video where that has occurred, because it didn't. Indeed, as the first claimant now belatedly admits, I explicitly stated that people should not harass the staff of the second claimant. And so here might be an interesting example as to where evidence comes in as against the facts that you state in a statement of case. So, for example, in my statement of case here on the right, my defense, I've said here the claimant admits belatedly that I explicitly stated that people should not harass the staff of the second claimant. There are two examples of that. First of all, it was less obvious in the first video because I was just commenting on the trademark aspects. So this bit here was about the reviews, and I said, people might leave bad reviews and so on, all of which they shouldn't do, because obviously that is not going to be genuine, because they won't be a genuine customer, etc. And then in the second video, these are transcripts from the video. And it was quite irritating, actually, because in the court hearing, the solicitor insisted that these were comments left on the video by me or by somebody, and that's not true. This was a transcript of the video that I was referring to. But again, this is a transcript from the second video. And as I said, in that video, this is verbatim, at least the automated transcript from YouTube, what I said. It says, but what it does say in the letter I was talking about here, that there were lots of unkind, threatening, and generally bad comments made about the company and anyone within the company, either underneath my video or underneath the other video. So, and this is word for word what I said. And so just to be clear, I don't condone that. I don't appreciate that. You shouldn't do that. I understand that YouTube's got a fairly strong filter which removes such comments, so I largely trust that. Those were my comments in my second video, or second and then the first video that I've just talked about. So those don't belong in the statement of case. So my defense here is a statement of the facts, which obviously they can dispute, but it was my statement of fact that the claimant accepted, that I'd explicitly said that people shouldn't leave those kind of comments. And so you can vouch for that. I've said that in this video. I said that in the previous video. I've said that in both of those videos, that people shouldn't leave bad reviews and they shouldn't leave negative comments. That's been my position all along. And that is why I blanked the names out, because there is no sense, there is no need in me deliberately ridiculing the company. This is an educational exercise as to how I dealt with and met this claim. So that was that in paragraph 15. Then in my paragraph 16, I relate to their paragraph 13.2. So I say I cannot comment on that as it relates to the cyclist. And so again, that relates to the cyclist. But then in their claim in paragraphs 14, 15, 16, and onwards until 18, are all legal submissions. They're legal arguments as to liability. They even talk about the Malicious Communications Act. They even set out the guidelines for social media offences and all these sorts of things, which is probably why this document was hundreds of pages long. Anyway, right up until paragraph 18, all the way down here, they say the defendants are liable for the harassment conduct caused by the postings of end users and on our respective YouTube channels. But again, as a matter of law, that is just not true. We are not liable for the third-party comments. As Judge Eardley KC, Deputy High Court Judge Eardley, said that it will be a very far-reaching effect on the freedom of expression for us to be held liable for their comments. But just to be clear, I don't condone those comments. In other words, I don't support them. You should not make those negative comments. As for paragraph 19.1, it is denied, and then I put forward my positive case. So then we look over what are they claiming. They say that I combined with the cyclist to accuse the first claimant falsely of unjustified trademark infringement threats. But as I said, I deny that because I did not combine with him for anything at all. It says here that I merely commented on the trademark infringement threat to the cyclist, having been alerted to it. And that was the guess by Deputy High Court Judge Eardley KC. That was his guess, that I was just alerted to an interesting topic for a video, which is exactly what happened. I commented on that threat and that was it. In my defense, I say, as stated above, their representative, the solicitor, later admitted that those threats were misconceived. Now, again, for full transparency, the claimants were then given different advice and they carried on with the claim regardless. My paragraph 19 is talking about their paragraph 20, and I say that save that I cannot comment on what comments they may have been subjected to, paragraph 20 is denied. And then again, I am not and cannot be responsible for the comments of third parties in relation to what anybody has done. And if that they were aggrieved by those comments, then the remedy lies against those individuals or Google as they host the site where those comments appear. Paragraphs 21, let's move down to, and you can see here they've put, again, in the claim on the left, lots of more legal arguments about those comments. But again, they have no place in a particulars of claim. Now, again, bearing in mind, I had no interest who anybody was in my first or second video. My first video was commenting on the trademark aspects, and my second video was commenting on the letter that I received from the solicitor. My defense, I say paragraphs 21 to 24 are denied, because these are talking about alleged breach of data protection. I say I have not processed any personal data. My paragraphs 21 and 22, again, I deny that I've processed his data. I deny that I've infringed GDPR. My paragraph 23, talking about their paragraph 28 and 29, so they talk about their European trademark and the goodwill and reputation of that trademark. Now, there's no sense in denying that they have that European trademark. As to a legal argument, again, it doesn't belong in my defense. But a legal argument would be that that European trademark is not enforceable in the UK anyway. I think they do have a UK trademark, but it wasn't pleaded here. And as to 29, that's talking about the goodwill and reputation. In my paragraph 23, I say I cannot comment on the reputation or financial circumstances of the second claimant, having no knowledge of such matters. It is not my business to go start looking at the history and the financials, etc. And even if I did, I'm not in a position to admit or deny or talk about those things. It's just not within my knowledge, so I've no need to comment on those. My paragraph 24, talking about their paragraph 30, again, that's talking about their goodwill and reputation and when it existed. I say that apart from the fact that I can't comment on the goodwill or reputation, it's admitted that whatever it was existed before we did those videos. Then in their paragraphs 31 to 33, they make allegations against the cyclist about the trademark infringement. And again, I say I cannot comment on those as they relate to the first defendant. My paragraph 26, talking about their paragraphs 34 to 36 about alleged trademark infringement against me, insofar as they relate to me, they're denied, and I have not combined with the first defendant. In my paragraph 27, talking about their paragraphs 37 to 41, they are talking about, well, they say that they had loss of business, goodwill and reputation. So far as they concern me, they are denied. I've not sought to incite any adverse publicity against their company. And again, they're invited to identify any content within my videos complained of that amounts to such incitement. Because, to put it bluntly, I didn't. In fact, I said it should not. One driver driving badly, I think the words I used, should not harm the reputation of a company. My paragraph 28, as to their paragraph 42, I cannot comment on any assumptions made by the claimant here. They say that they've wasted advertising expenditure. I can't comment on their assumptions. I deny that any trademark infringement against the second claimant company. And they are put to proof as to any financial losses. And then finally, my paragraph 29, for the avoidance of doubt, my contention is that the claimants in this matter are solely the authors of their own misfortune. Any negative impact on them arises solely from the driver publicly committing an offence and the claimant's subsequent attempts to suppress public participation in commenting on the matter. So that is why I say it's a slap. I've always said it's a slap. It was designed very much to take down the videos, to prevent further criticism publicly of this driver, of this incident. But now this makes this whole thing a new event, because suing somebody because they don't like the comments of third parties is wrong in law. And to do that as against protect their reputation by saying whoever the driver is will be spoken to, etc., that's what the company could have done. Instead of that, they threatened to sue the cyclist, they threatened to sue me, then they did sue both of us, and eventually, a year and 4 months after the original letter, as I stated in the opening, we were due to go on holiday the very next day, and I got this thump on the doorstep with this huge wad of documents that I had to meet. And so that is in the back of your mind all along. Even as a barrister, you know, these things, you still have to deal with them. There is still the costs risk, because the solicitor put in a cost schedule for over £28,000 for a 1-hour hearing for the injunction application against me, which, had I not agreed to take down the videos pending the final resolution of the case, and if that hearing went against me, I'd have had to share in paying those £28,000 in costs just for that one hearing. And that wasn't the substantive claim. So these do play in the back of your mind. You do have to deal with it all the way through. But I reiterate, I am absolutely a champion of free speech. I am not just going to back down. These things should not happen in my view. In my view, this was a slap, shouldn't have happened, and shouldn't happen again. And so I do this video in the hopes that you can appreciate how you respond to those things in a claim and how you deal with those matters. So that was the defense. There's a lot more different things to unpack and discuss in this whole case, this whole charade of this claim against me. Do subscribe to the channel, leave your questions below. But again, I'll reiterate, this wasn't in any way to insult or ridicule, or certainly not to invite any negative comments and publicity either on this video or elsewhere. Certainly not directly to them. Just don't do that. So with that, I hope you found that useful. Please do subscribe to the channel. And as always, thank you for watching.